go, guys. Good morning, everyone. Welcome to Policy and Regulatory Environments, a Mobile Perspective. My name is Robert Jaron. I'm Senior Director of Government Affairs for Qualcomm Incorporated. I will be the moderator of this esteemed panel. Everyone has a program. You all know who we are. So I'm going to just go right off the bat and start off with a very simple question. I'm a lawyer, I'm a critic, I'm a cynic, and I really want to ask, what is the most frustrating thing about mobile health that you feel on a day-to-day basis? And I'll start off with Mr. Ravitz here on the end.
Thanks, Robert. Can everyone hear me okay? No? Yes? No? A little closer?
Closer, like you mean it.
How about now? Okay, well, that should be better. The most frustrating thing, and you know, I can only go by how my clients feel, obviously, because they're the ones on the front lines, and it's really going to vary from client to client. But we see different issues for the smaller entities, the developers. We see a lack of certainty. I think that's one of the most frustrating things. Is what are we? Are we a medical device? Are we not a medical device? If we are a medical device, then what? What then? Are we, do we have to go through a regulatory approval process? Do we have to, go through jump through all these other hoops to, define ourselves as a medical device company? We're just not set up for that kind of thing. Can you help us? And I think that, obviously that for those kinds of entities, not understanding what they are is a huge source of frustration, because, obviously there has to be a lot of planning involved with launching a product, and then once they get out on the market, how do they establish themselves so that they can, be compliant with the law? For other types of entities that are larger, there's still sort of a similar, what are we? I remember, several years ago, a California-based technology, a very large one, shall go nameless, had an online store where you could purchase apps. And I remember the question that was asked at that time. Again, this must have been 3-4 years ago. There are medical apps in our marketplace, or in our place where you can purchase things. Are these, are we a medical device? Is our device a medical device? And that really triggered, I think, back then, kind of where we are now in terms of what are we, and how do we plan for our own product to ensure that we can operate in a compliant environment.
Great, and a little later we're going to get into the mobile medical applications guidance document that I'd like to ask you some questions on. Marcy, how about yourself? You're a gifted attorney with a very vast portfolio, privacy and security being one of the ones. How about yourself? Biggest frustrations in mobile health?
Dropped calls.
There we go. All right. Reality. All right.
Okay. Coming at it from a privacy and security perspective, I think the frustrations as experienced by clients, companies, healthcare providers are along the same lines that Jamie just described. So what I will call it is they live in a climate not only of regulatory uncertainty in terms of what rules apply, but they're also working within a framework, a privacy and security framework that was developed without mobile health in mind, because it didn't exist it didn't exist much in the 1990s when the HIPAA framework, for example, was first established. I could say this with authority. We didn't do introductions, but before I'm a partner and I'm a co-director of the privacy and information management practice at Hogan Lovells, and before that I was the Deputy General Counsel at the Department of Health and Human Services, and I was the lead lawyer on the HIPAA rules. And the policy debates and the hard policy questions that were being addressed at that point in time never anticipated healthcare delivery through mobile phones or tablets, never anticipated the kinds of geolocation information that's available today. And so from a privacy and security perspective, you take sort of these age-old principles, privacy principles like notice and choice and consent, and also the concept of minimum necessary. And I think the great frustration is feel like the stakeholders want to do the right thing in terms of privacy and security, and they find often that doing what the rules require interferes with the user experience in ways that are quite detrimental. And so it's the frustration of really wanting to follow the rules, feeling like the rules weren't written for this world, and not being quite sure what to do about it.
Thanks. Lee, how about yourself?
Thanks. So I believe that in terms of mobile health, and one of the most frustrating issues is that I think that there's a trend, just like we see here at our conference, that mobile health is cool and there are many, many different solutions. But I think that we need to get to the point where we take things such as security seriously, and I don't mean just simply end-user security, which is certainly a huge issue in terms of cybersecurity, but also the design of the mobile devices themselves, the design of applications, the design of medical devices, and plugging the vulnerabilities that are present, which hackers and others can exploit and leach data from.
And Ali, how about yourself? You're coming from the perspective of an entrepreneur. What's your biggest frustration in mobile health?
So, good morning, everyone. And first of all, I wanted to thank everyone for taking the time to attend this session. Very excited to be here, and I'm humbled by the group that I'm with here today. Marcy mentioned back in the 90s the HIPAA regulation, and it was in the early 2000s when the HIPAA security rule came out, and the very first implementation specification in the regulation is risk analysis. And I think the frustrating part is that that's a required implementation specification. Change is constant. If anything, change will be even more faster in terms of technology and the foundation for information. But a lot of organizations do a very poor job, even today, large and small, across the country, providers and payers, business associates, in terms of doing a really comprehensive and thorough risk assessment. And I think it was brilliant on the part of the people who wrote the regulation to put that as the #1 implementation specification. It should mean something, because that provides the foundation for your policies, and then eventually what combination of technologies and controls an organization may select to secure information. So the end of that is, as we look ahead to 2013 and beyond, I think we've got to change our mindset, less about infrastructure security and more about information and data security. That information is going to be moving, it's going to be fluid, it's going to be clouds and virtualization and all of that. The platforms are going to become more diverse and change. What's critical is that we have a soft shield around that information as it moves, and I think that change hasn't been reflected in many organizations. It comes through a comprehensive risk assessment.
Okay, so I'm noticing a theme here. In particular, I'm going to go back to, obviously, Marcy and Jamie here. The theme being that we have rules and regulations that were designed, drafted, established 20, 30 years ago, some even just a decade ago, but that really did not contemplate the current state of the evolution and continuing evolving mobile health and really much broader health information technology landscape. That said, Jamie, FDA issued their mobile medical guidance document about a year and a half ago. They took in 700 pages of comments. They held a 2-day workshop. They reached out to every stakeholder that they could, took it all under advisement. We haven't heard anything since. What's your take on the mobile health guidance document? What's your opinion on the guidance document and where it's going?
Well, that's a great question. I thought the guidance document, this is my personal opinion, was a pretty good first shot. I think it's a very tall order. You raised the point, and very well so, that we're working with a regulatory structure that's quite old, and when you think about the, and from a food, drug, and cosmetic standpoint, because that's the name of the act, the Food, Drug, and Cosmetic Act, they didn't even contemplate medical devices in 1938. Medical devices weren't started to really be regulated until 1976, and at that time, in 1976, it was basically it was basically, okay, if you're on the market now, we'll let you continue on the market, but anytime after 1976, you're going to be subject to this regulatory regime. That's what, 40
Right.
years ago, almost 40 years ago. So you think about sort of the evolution in just 40 years of where we were. These were the FDA and the Congress was dealing with products that when you dropped it, they made a sound. We're not in that world anymore. I mean, there are some products, of course, that are still purely mechanical, that are really traditional devices, but it's a new world. It's a new world, and for FDA to be able to adapt in such a fluid environment, I think is extremely challenging. There's a lot of different expertises at FDA, and they do a great job in sort of balancing everything that they've got on their plate. But it's hard to be good at everything. They tried a software policy back in 1998 when they realized that that software embedded in medical devices is the future. And they kind of whiffed. They withdrew that policy and kind of moved forward from there. But little by little started putting out policy through guidance documents on how to submit 510K applications, with embedded software. So it's been an incremental approach to an extremely dynamic and fluid industry. So I think FDA did a pretty good job in its first draft in trying to really draw a line around, what is a mobile app? And yes, there's a lot of voices out there, and we've got a burgeoning industry. So it's a balancing act. You've got economic concerns. We're in sort of a difficult economic environment. We have a burgeoning industry. We don't want to over-regulate such that we're going to end up cutting the industry off. Or stunting its growth. So the idea was to kind of draw a line around what is a medical app. Let's try to give some predictability, some certainty to the process. Yes, in 2011 the guidance was first established, and there were a lot of comments, a lot of feedback from industry, a lot of different opinions on how things ought to be regulated. And remember that there's a lot of different perspectives. There's your app developers, there's your online stores, there's your other types of networks. I mean, there's a lot of different players involved, from traditional medical device companies all the way down to just technology companies. These are companies that aren't used to being called or referenced a medical device. It's been, there's been some talk, and the FDA's goal all along was to try to, by the end of the year, try to finalize a guidance. But, here we are at the end of the year. I thought that was ambitious, to be quite honest with you. Here we are at the end of the year with no guidance. But that's okay. Better to get it right than to rush something through and have it wrong, and because of the potential impact. In a recent publication, I think it was in the Federal Register, FDA had announced that the mobile app guidance was on its A list of priorities. So that's really the first time I kind of saw FDA saying it's not going to happen this year. I haven't seen anything official other than that, but that's kind of where things stand right now.
Great. Marcy, I'm going to put you on the spot a little more as a former regulator. Do you think the old HIPAA framework is still applicable with today's ever-evolving health IT systems?
It is. It is. In terms of certainly the principles apply, and there are ways to accommodate the requirements, which are based on sound principles. So, for example, the requirements of HIPAA are based on, again, the age-old principles. Notice, you have to provide notice. Now, how do you provide a HIPAA notice in the context of an app and a small screen? I think notice is still a good thing, but it would be helpful for the regulators to rethink what might be permitted in a mobile context. So I don't know that. So I think that the concept still applies, but it would be helpful to have some updates and some guidance. and some flexibility.
And this is very interesting because I'm hearing the same thing from Jamie from an FDA perspective, and you're dealing specifically with another agency, OCR, presumably, and they actually have some things through high tech that they're supposed to be divulging, one of which was recently the de-identification guidance. What are your thoughts on that guidance document as it applies to mobile health?
So the de-identification guidance that came out last week from the Office for Civil Rights, or the long-awaited guidance, I should say, clarified the already existing de-identification standards, which, as you know, are quite stringent in the context of health information in the U.S. There weren't any big surprises, there weren't any major changes, but there were some very helpful clarifications. And so to the extent, in the context of mobile health, there are a number of providers and data aggregators that are pulling information and housing information put through mobile devices, tablets, phones, and electronic health record systems writ large. And I think the guidance will help in terms of what's permitted, how do you de-identify it, and more clarity can encourage more and better de-identification, which will enable more and better uses of the de-identified data. So I don't think there was anything earth-shaking in the guidance, but I do think that it was helpful and that it clarified a number of the way that HHS approached providing the guidance was it looked at the questions it had received over the years and tried to answer the ones that it could. So helpful, but not earth-shattering.
Gotcha. Now, and again, consistent with the theme that we're talking about, the ever-evolving evolution of IT and laws that should keep pace. Lee, IP is something that has really been kind of quiet in this mobile health space for the last 3 or 4 years since it began to really take off. What are your thoughts specifically on patent enforcement activities? And then if you can further elaborate a little on some of the proposed legislation that's sitting out there, like the SHIELD Act, and maybe your thoughts on the America Invents Act and how it affects mobile applications directly.
Okay, so just by way of background, under the U.S. patent system, processes are certainly eligible for patent protection, so you can obtain software patents, including related to mobile health applications. And certainly, being a patent attorney, it is the right of the patent owner to send cease and desist letters to entities that they believe are practicing the technology or that are selling an infringing version of the technology, or even making it as in a vendor, as in a software developer that might be making infringing technology. That being said, I think that there is a constant war in terms of the patent owners wanting to enforce their rights and sending out cease and desist letters, sometimes massively, to those that it believes are infringing. And the question then turns to what you do with once you have that letter. So I think that it's a myth that as soon as you receive that cease and desist letter, you will be sued for a patent infringement. Cost for a patent infringement is huge. It can be anywhere from $500,000 to millions of dollars, according to the AIPLA Economic Survey. So there's that constant battle between the IP owner's rights and the responses to whether or not you're infringing. So that won't go away, and that's certainly been a problem ever since the patent system has been in place. There's always that dynamic. It's been called to my attention and reading the news that there are some companies that are claiming patent ownership in terms of patient portal technology, and under meaningful use there is certainly a requirement to have one's patients to view, download, access, transmit their information, their patient information, and so that's a problem. I mean, it's a problem in terms of the providers and hospitals that wanted to comply with that meaningful use requirement. So that, I think that it's up to the healthcare industry to resolve that with the entity or entities claiming to own that technology by challenging the patent either by way of a lawsuit or by way of a re-examination of that patented technology. And so that turns to the SHIELD Act of 2012, which was proposed. The SHIELD Act aims to go after the so-called patent trolls, that is, entities which do not practice the patented technology. They just merely acquired the patents so that they could sue others for infringement and essentially get money. So it essentially says that the plaintiffs, who are the patent trolls that bring frivolous lawsuits, owe the attorney fees and such as a result of bringing a frivolous action against a defendant, who could be a hospital, pharmacy, provider, whomever. So that's that. But you know, the real state of IP enforcement is that most patent infringement cases are rare. Not everyone has $500,000 to litigate, so chances are you will be spending some money with your patent attorney to try to figure out a way to respond to it, but chances are it won't go to litigation. So I don't think that the SHIELD Act would be relevant, except for probably very large or well-oiled companies or entities that can actually afford to do battle.
All right, and Ali, again, from the perspective of an entrepreneur, you spoke about privacy and security and some of the things that are important to you. Being responsible for an organization, how do you demonstrate encryption, for example? How do you go about really proving that you are in compliance with the law, let's say?
Thank you. I could see Lee was getting really excited about patents. That's her area of specialization. Is everyone excited? I can't wait for audience questions. But you know, encryption comes up twice in the HIPAA regulation, both the places as an addressable implementation specification. And you know, when we talk about mobile health, just this year alone, 2012, HIPAA work has taken me to Philippines, to the land of my birth, India, to Canada. And you know, the two things that I see as we go into 2013 is that there will be a huge increase in the diversity of platforms, and that Thomas Friedman's "the world is flat" probably changes to "the world is flatter." You know, all over India, I know when I was there in Bangalore, Chennai, Gurgaon, Delhi, Mumbai, all of these cities, enormous mobile applications being developed, a lot of software development. And the question that, you know, we all have to ask ourselves is, in the area of encryption, is it baked in or is it bolted on? And all encryption is not equal. Key strengths are different. Algorithms are different. And how do we ensure that we have the appropriate encryption policy for our organizations and the appropriate encryption technologies and capabilities that are in fact baked into the application and our infrastructure? So, and it's across the devices, the applications, the operating system capabilities, and all that. So, for example, just because iOS provides built-in support for AES encryption does not mean that all the data on that device is in fact encrypted. And so where does an organization stand with respect to its encryption policy and capability? So just that one narrow area itself you know, requires significant thought on the part of an enterprise to ensure that they address it appropriately.
And Ali, let me probe for a second there. Does that change, you know, from the enterprise level to, let's say, the actual tangible level? Like, let's say your device is lost or stolen. You know, what kinds of ways of encrypting, you know, how do you approach that? How do you, as an entrepreneur dealing with this, how do you approach that?
Right, that's a very, you know, it's a really good question. And to take a step back from that is, you know, devices will, you know, one of the comments I've always made in my presentation is there's no such thing as a 100% secure environment. That's why even in the HIPAA regulation, you've got risk analysis, and that's immediately followed by risk management, because you're not going to eliminate risk, you're going to mitigate risk. And so the first step is how does an organization demonstrate that the device that had in fact been lost or stolen did in fact have encryption capabilities enabled, and that the user did not bypass that encryption by removing a passcode or something of that type. So MDM, mobile device management, becomes really critical. Having an enterprise centralized solution, because skill sets are expensive, software and applications relatively are not. So you want to make sure that you look at that very carefully to ensure that you look at that mobile device from a life cycle perspective. And I'm not sure how many in this audience, because very few things in life get me excited anymore, but the other day when I was looking at the NIST publications, NIST special publication, they have one out there, 124. If you haven't read it, read it, revision 1, which talks about mobile device life cycle from an information security and management perspective, and tremendous work done by the people at NIST. So, that's it.
Wow, and I thought I was a cynic. Nothing excites you anymore? Come on, Ali. You can't say that with a straight face. I don't believe it. Okay, so Ali was talking about risk, and Jamie, we're going to talk about a different kind of risk. Have you seen any enforcement activities from the part of the FDA? We hear about some FTC enforcement activities on trying to get some mobile apps off the market that, obviously aren't based on science or any scientific evidence. But how about the FDA or other agencies for that fact?
Well, you're correct in that the FTC has had a few examples of enforcement against companies using their powers under the FTC Act in Section 5. And the FDA and FTC have, when it comes to medical devices, they have sort of shared jurisdiction in terms of enforcement. FTC has a bit of a different standard than FDA, and there are certain areas where FTC tend to be a little bit more bold than FDA in terms of enforcement. I think that FDA is a little bit leery to start with enforcement because, and I'm dealing with this in another context, not in the mobile health area, trying to get FDA to take action on a certain category of products and issues. FDA, their policy is it's not really appropriate for us to take enforcement action if people don't really understand how they're even being regulated in the first place. While we at FDA, we as practitioners have a better understanding and we understand the applicability of certain laws and regulations with respect to a product area, we cannot impart that same amount of wisdom on others who are actually practicing the art to really understand at the level that we do. Therefore, it's not really fair for us to begin enforcement without having sort of a clear level playing field. People need to understand what regulations pertain to them, and they need to understand, sort of what the rules of the game are. And I think from FDA's perspective is kind of getting out to people, here are the rules of the game, and that's really why policy and guidance here is important. Sure, there are some areas where in the more traditional medical device space that may have some mobile health type applications. FDA may put on them a higher level of citizenship because that's a more sophisticated medical device company. But when we talk about mobile apps that are coming from outside the traditional device area, we're not really seeing much from FDA, and I don't expect to see much until we have a more concrete policy.
And Marcy, I wanted to go back to you on something Lee was talking about. In stage 2 of meaningful use, the most recent meaningful use iteration, there is a requirement in there, and I believe it's a core requirement, where doctors have to be able to allow patients to view online patient information within 4 days, and then I think 10% of them or 5% of them also have to allow patients to transmit to others, have the ability to transmit to others, otherwise they'd be not in compliance with the rule. Given that, those requirements, do you see mobile and really the Meaningful Use Incentive Payment Program as being a driver of mHealth. Rather, so let me say it that way. I would love to talk about reimbursement, but I feel that's an entire other panel. But I really would like to draw on the expertise that we have here. So, does the Meaningful Use Incentive Payment Program really drive mHealth?
I'm going to give you the true lawyer's lawyer.
It depends.
Yes and no. I think a couple of things on this. One, the opportunity for meaningful use to drive adoption of mHealth, I think, is viewed by many as a missed opportunity. And stepping back and thinking about it, sometimes when, file this under frustration, right, sort of the list of frustrations. I mean, there's a lot, there are many folks who feel like mHealth Mobile is poised to make meaningful use meaningful. Why aren't the regulators doing more through that regulatory process to encourage and to drive adoption? And the answer is easily understood when you think about the context for the Meaningful Use Program. So I'm going to pull the camera back and look at the bigger picture, which is the Meaningful Use Program started as part of the stimulus package. And what was the point of the stimulus package? It was to get dollars out the door and into the economy. So you have an agency, HHS, ONC, CMS, that was tasked with developing the Meaningful Use Program and getting the dollars out the door, which meant that the regulator's challenge was to strike a balance between driving adoption primarily of EHRs and making sure that they had a standard that pushed people, but at the same time a standard that stakeholders could meet so that they could accomplish the primary goal of getting dollars out the door. So although we may have liked to see sort of large creative thought, including and embracing mobile and patient participation, the reality of the time frames and what was doable to get the money out the door was an externality that was very limiting. So we don't see as much as we might have liked in terms of driving. And even that stage 2 criteria around making records, health records, available to patients is extremely controversial. Even that little bit that they put in is extremely controversial because the providers, the hospitals, the doctors, who are implementing the technology and becoming eligible for those incentive payments are saying, now you're telling me not only do I have to have certified technology, and not only do I need to be using it in certain ways in order to qualify, but now in order for me to qualify for my incentive payments, I have to make sure my patients who may or may not be interested in doing this are in fact accessing their records electronically. So it is, now one might say, yes, that's why the requirement is in there, and it is the industry's job, the hospital's job, the doctor's job, to make it easy enough and appealing enough, because we know from surveys that patients are in fact interested in accessing their health records electronically. But that's a little bit of the that's a little bit of the color around what's been difficult. Although I do think that mHealth and mobile is taking up more space in the debate and the policy conversations around it. So there's an interest in driving, but there are some real rate-limiting factors.
Great, great. And in what you just said, I think I'd like to probe on that a little more. You see mHealth taking up a bigger part of the debate. Explain that for some of the folks that may not be as familiar with what the agencies have been contemplating and have been dealing with.
Yeah, I didn't mean in terms of the specifics that you'll see coming out in the regulation.
Agreed.
It was
agreed.
more
And I
right
didn't want to give that
of an
impression.
atmospheric in the following sense. The key folks that are thinking about and driving what the Meaningful Use Program requires, the Office of the National Coordinator, the Health IT Policy Committee, the Health IT Standards Committee. What you see over the last 2 years are mobile stakeholders increasing their visibility in the policy debate and conversation. And the more sophisticated, more visible, well-conceived efforts that go on directly with the policymakers and on the Hill, the more and better results we're going to see. So you see industry teaming up with patient groups more and more. You see industry groups supporting patient groups more and more because they see patient groups and consumers and consumer groups as an effective voice with some of the regulators around driving the change, and the regulators want to hear both from consumers and industry, and so looking for more opportunities to testify, to submit rule comments, and the like. So that's where I think you're seeing more visibility, particularly in the last 2 years.
I definitely agree with that. Lee, let's expand a little from what you were talking about earlier. We're going from IP now to more just a policy perspective, kind of a 10,000-foot view. What are your concerns, or do you have any thoughts on things like, basic terms? Terminology is a big deal, especially when we're talking about rules and regulations. So things like cloud computing or the increased adoption of mobile computing or mobile applications, even just wireless technologies. What are your thoughts and feelings on rules and regulations pertaining to those terms?
So I think that the most vague term of the ones that you mentioned is concerning cloud computing. And in fact, the NIST is released a final definition of what cloud computing is, but it's version 17. So what we understand cloud computing today is going to change as well, as they acknowledged in their document. So I think that in terms of the definitions and the policies and procedures surrounding these things, such as cloud computing and wireless and whatnot, the policies and procedures certainly need to be living and breathing documents that keep pace with how what the definitions are, because the technology will certainly change, and it's changing quite quickly. So I would say that the NIST has excellent white papers, their special publication documents in terms of these technological definitions, and that's certainly a resource to go to. And they also have wonderful policy guidance. So I would certainly make that suggestion that their framework and their guidance is certainly among the best out there.
Thank you. And Ali, we're going to go back to you on encryption. I like your thoughts on encryption. Give me, talk to me about enterprise encryption.
Sure. So, if you take a step back, if you look at the diversity of the types of security controls that an organization may possibly implement, firewall systems are typically regarded as the first line of defense. That's your DMZ. That's what connects you to the outside world. And then you might have a multitude of different types of controls, intrusion detection, prevention, and the like. But the very last frontier, the very last control, the very last line of defense, if you will, is encryption. Because that's what, if all other layers are compromised by hackers, then that's what potentially could secure the data that is there. So when you look at enterprise encryption, it's very important for organizations to look at it from a data perspective in terms of the architecture, and then standardize on the algorithm in terms of the policy, standardize on the key strength, so whether it's AES 256-bit or whatever that might be, and then you have different transmission alternatives in terms of enterprise the wired environment, the wireless environment with its challenges, and then I think another big challenge inside healthcare these days is the clinicians, the physicians, the nurses are increasingly using social media, texting to move PHI out of the organization, and that's going over a network infrastructure that's not necessarily controlled by the enterprise. So those are areas to look at encryption very seriously to kind of see what may work for the enterprise.
Yes, Lee.
If I can add something, I was hoping that Ali could also address the notion of why encryption alone is not enough. such as in recent news, the LinkedIn data breach, the passwords were encrypted. But certainly, I was wondering if Ali could share his thoughts in terms of why we need strong passwords, what strong passwords are, and also additional things that we could use to secure our data in addition to encryption in terms of added layers of protection.
Lee is beginning to get me excited here. But, you know, in the world of information, don't take that in the wrong context. In the world of information
I'm
security,
clearly not as good looking as Lee, so I don't want to take that personally. It's all right.
in the world of information security, I think all security experts agree, you know, the three pillars of security: confidentiality, integrity, availability. You got to look at mobile health information in that context, especially as you develop and articulate your policies. But Lee's question and her point is a good one. Encryption is one of many controls, many areas that an organization has to address. Two in particular that stand out, that kind of marry with encryption. One is the front-end authentication, and you want to make sure that you've got strong authentication capabilities. Not all authentication is equal. And at the back end, which becomes really important because all of you here, regardless of what we all do, will experience security incidents, and we have to manage those incidents. So at the back end, audit controls become really critical. And, you know, I always make the comment, security incidents equals security intelligence. And the question is, do we have intelligence in our controls? And do we have the skilled individuals in our in IT and other departments to be able to harvest that information on a timely basis? So I think the combination, going back to, you know, your question and Lee's comment, was authentication along with audit control capabilities, log capabilities are tremendous. And one last point that, you know, I'd like to share, because just from experience, just like you have those three pillars of security I just mentioned, I think three invaluable sources of reference as you look to articulate your organization's posture with respect to mobile device and information privacy and security. The ISO 27000 standard is a really critical reference. PCI's data security standard, that's very centered on cardholder information but has invaluable information that potentially could influence and then like we've been mentioning here, the NIST special publications.
I'm glad that we're talking about encryption and security, and that's something that I'm actually going to go to Marcy about right now. Marcy, OCR yearly puts out a report, if I'm not mistaken, on some of the breach notifications that have happened over the course of the past year, or more the breaches, I believe. And I'm going on memory here, so please forgive me if I'm incorrect. From what I remember in years past, the issue of breaches was mostly, I don't want to call them inside jobs, but things that happened because of human error, as opposed to proactive hackers breaking into a system. It seemed like those were much less than the others. Can you talk about that, and can you talk about some of the aspects of the actual enforcement of some of these breaches, and really about the nature of those breaches? Because I think a lot of people in the industry have this idea that there are hackers there sitting at 7-Eleven trying to hack into someone's pacemaker, for example. You know, what are your thoughts on that?
I think what we've learned, well, first, let me start in a different place, which is to say, for technology companies, for technology providers, for healthcare providers, for health plans, breach is very often top of mind, right? That's in some ways the worst thing that can happen because it's public and it can be costly. So there's a lot of talk about breach, and certainly that's on the regulator's mind. When we look at enforcement by HHS, breach enforcement is the top of the list, and we have the most data on it. And an astonishing number of breaches and investigations, and OCR investigations, center around some kind of a data breach. And what happens is it becomes more of a self-fulfilling prophecy, because the better the agency gets at investigating and taking enforcement actions involving breaches, that's more of what they want to do, because people like to do what they're good at. So if So given the fact that an astonishing number of breaches begin with some kind of a lost device, usually a laptop, but increasingly a mobile device, if your mobile devices are not encrypted, you are behind the curve. You were not home when HHS called. It is very clear that the expectation is that in the healthcare context, devices will be encrypted. Now, as Ali was saying, encryption can mean different things to different people, and all encryption is not equal, and you need to consult with your experts. The people that are really excited about NIST 124 Revision 1, which is not on my list, to really understand if the encryption solutions that you're implementing are sufficient. But we know a little bit more about what you ought to be doing than just encryption, because encryption is not enough. What HHS wants to see when they're investigating a breach is, one, that you had a plan, that your employees know how to recognize a breach and they know what to do and how to report it up when it happens. What else is HHS looking for? Did you have a plan? Were your folks trained? Did you implement the plan? Did you act quickly? Did you act in good faith? If you are a business associate, they're going to be looking at those things, and in what way and how quickly did you by the affected covered entity. So in the HIPAA context, there's a lot of focus on breach, and the bottom line is encrypt devices, have a plan, and implement the plan when it happens. In some ways, breaches are very bad things that happen to companies, healthcare providers, and health plans. In another way, the silver lining, if there is one, is it is often a driver for improving security in very significant ways. It gets the attention of the top of the organization, and data is almost inevitably better protected going forward.
Lee, go ahead.
So I think that Ali and I will tag team here as we're sort of the techies here. One additional source of data breaches might be inside of your clients' organizations or your organizations. US CERT has an excellent white paper on insider threats. Your IT people that have authorization to access the sensitive data, what are they actually doing with it? If they happen to be a disgruntled employee, is there perhaps a potential in terms of compromise of the data? So this was a topic that we discussed at length with the Pennsylvania Chamber of Commerce when they had their IT security conference. So that's certainly one thing to think about. In many organizations, that could be a problem. A few additional sources of data breaches, which one might not normally think about, and this is where Ali and I can tag team on, is social media. How many of you use your health information system, and yet on that same machine you do social media, such as Twitter, which has shortened links? Do you necessarily examine what that shortened link leads to? If you click on it, you might actually download a Trojan horse program that might actually surreptitiously send your data somewhere else to an unauthorized individual or entity, and you might not even be aware of it. The third thing is, I think that it's very important to have a security incident and response plan if and when you do have a data breach. But one of the things that I think in mobile health is the new challenge is, how do we actually know when we've been breached? There are malware programs that are out there that are actually machine-made, and the signatures are not known. And so I think that the antivirus software market is trying to catch up with regard to their heuristic detection and other methods as well. But it really is scary. I had recently attended a FBI InfraGard meeting, and they had said that antivirus software programs are only effective as to 12% of the malware that's out there. So what are we going to do about the remaining 88%?
Ali, do you want to follow up on those thoughts? Or?
Yeah, no, I think those are all excellent points, what Marcy and Lee made. The only, couple of points is, as we look ahead to 2013, I think from a threat perspective, mobile information we've got to be aware to protect the environment from what's referred to as APTs, Advanced Persistent Threats, from the outside. I think the numbers that I've seen from IBM and Trend Micro, 60,000 attacks every business day on the infrastructure. So, that's occurring and we've got to, and then I think what Marcy talked about was also when you look at the information publicly available through the OCR site in terms of breach, there's a lot of unauthorized access to information, and again, that's where having the appropriate encryption audit capability is going to be very critical for managing your breaches.
So switching gears and going to a different kind of safety and efficacy. Jamie, I am a garage entrepreneur. I've developed a wonderful app which is basically a run keeper. Okay? It doesn't really talk about curing, diagnosing, or treating anything. However, in my marketing material, I mention the use of this app may lead to betterment of conditions such as congestive heart failure. And I receive an enforcement notice from the FDA 6 months after I launched this thing to market. Can you talk a little bit about the doom and gloom scenarios? And it's funny because I say that, and as a lawyer, people are always like, oh, no, you're crazy, it would never happen, so on and so forth. But I'm not sure that a lot of the garage entrepreneurs out there really appreciate what it means to bring a medical device to market and why it's so important that your marketing and your claims really form your intended use.
Yeah, I mean, that's actually that's a great question because it's, it really kind of hits home with sort of who app developers are, and it's, with all due respect, they tend to be largely ignorant of medical device and sort of these complex and very nuanced regulatory schemes. First of all, if you had an issue like that, I would say you have to push back. We're going to have to really fight hard. So, but in any event, no. Obviously, in the FDA world, the theme is you are what you claim. So, to the extent that you don't make certain claims about your product, then you're not going to be regulated as a drug. That goes to a certain extent, or a device, or whatever. That goes to a certain extent, because regardless of what you claim, sometimes your function and your intended use is just so obvious that that FDA will take action. But in general, you are what you claim, and therefore, when you're drafting things like talking about the intended use of your product, you can end up saying, well, the intended use of our product is to be able to map your run, and obviously when you run, you're going to be improving your cardiovascular health. Well, obviously, if you're improving your cardiovascular health, that's going to have other health benefits. So, you get into and you go down that slippery slope of, well, it's obvious this and it's obvious that, and obviously you'll improve your memory, and obviously you'll live longer. So now you've gotten to a mapping your run to use this program and you'll live longer. I mean, there are, you can take it to a ridiculous degree, but in general, getting tripped up in claims tends to be a very, I would say a big hole for garage entrepreneurs, because it doesn't stand to common sense. It doesn't stand, obviously, these are people who are thinking of, well, of course you're going to improve cardiovascular health, and of course you're going to do all these things. But that's the problem, is that this is where the rubber meets the road when terms from a regulatory standpoint, in that health claims can be hidden. They can be hidden in claims, and you can be sort of you yourself, even though you're making the claim, you're an unsuspecting victim of your own claims, just because you're ignorant of what the law says. So in general, what you're talking about, is would generally be regulated as something like a health and wellness app. That's sort of, this is now we're kind of making policy here. A health and wellness app is something like, a book that, helps you live better. Healthy living. Is that, is a book on healthy living, is that a medical device? No. Is a book that helps you plot, how you ran and how to improve how well you run? No, that's not a medical device. But where does it then cross the line? That line can sometimes really be hidden. It can be hidden with depending on what it is you're trying to say. Implied claims like where you're not making an express claim about something like about some sort of health claim, but you're implying that you can have some other health benefit. People who are developing these garage-type developers, it's a difficult landscape, and I think that's why we're seeing very little in terms of enforcement, particularly when it comes to this area, because I think FDA recognizes that we're dealing with a group of people that don't have this level of sophistication, and we can't impart upon them the type of sophistication that we would on a large medical device company.
And given those comments, do you feel that the agency has done, and I'm putting you on the spot a little bit here, but do you feel that the agency has been working well with the industry to kind of clarify that, given something like the mobile medical apps guidance document and some of the other guidance documents? I mean, that isn't the only one that they've issued. They've issued in the past years, off the top of my head, I can think of the home use initiative that they were looking at, wireless there, the radio frequency wireless document in 2007, et cetera.
So here's the problem, is that those documents are written toward people who understand the parlance, that's their vernacular. Even for me, going through the mobile apps guidance, I had to go through it numerous times, and this is someone who's kind of steeped in this world of this regulatory world and this regulatory maze, and understanding all the ins and outs of how a medical device is regulated. They're doing an okay job. But to be honest with you, to really get the message out and to really reach the people that need to be reached, we need to come up with a way for it to be more plain English. I think that's one of the challenges here, and it's one of the challenges with getting this guidance through, is that you've got a wide spectrum of people, from very sophisticated device companies to these garage developers, and the folks, these are the kind of the nuts and bolts who are putting things in the in the Apple iTunes store, or putting things in the Android marketplace, and these are the people that you're going to see the most kind of development and the most development from, and it's those people that we need to be able to talk to.
And I think that will even transcend the mobile medical apps guidance document. It's so much wider and broader, mHealth in general. It's not just apps, as we know. So I'll use this as an opportunity to plug a new piece of legislation that was introduced just yesterday called the Healthcare Innovation and Marketplace Technologies Act. Representative Honda introduced this bill, and it's offering to establish an Office of Wireless Health at the Food and Drug Administration to coordinate with other government agencies, collaborate specifically within the CDRH and at the commissioner level, so it's a little higher than the CDRH, to deal with this ever-growing issue of wireless health. It also looks to establish an mHealth developer support program at the Office of the National Coordinator. It's looking to create a Disruptive Technologies Prize program, much like the X Prize. It's looking at issuing a challenge grant program for small innovation grants, a low-interest small business loan program, and finally some tax incentives for medical care providers to deduct costs related to non-EHR technologies. And I believe that the idea behind this bill is for driving innovation for non-EHR health information technologies, which to a company like us and this industry, I believe, would be music to our ears. So I really would like people to check that bill out. Having said that, I think I should now open it up to questions. I can see that Hank Fanberg is dying to come up to the mic and ask a question. So is Rick Scully. So is Jason Brook and Neil Newberger and this lovely young woman. Please.
Hi. I'm Sharon Paciani, and I work for the military healthcare system, obviously. You've spoken with a lot of rules and excellent panel, by the way. Excellent panel. You've spoken about a lot of rules and regulations and guidance documents, et cetera. Okay, so what if somebody comes to me and says, I want you to use this as a great mobile app, use it in your primary care. Where can I go for guidance documents? The FDA, I've heard, FTC, wherever, to read about it so that I can ask good questions of that person to make sure that they've addressed this diversity of issues, whether it be encryption, whether it be regulation. I would appreciate some guidance on that. And thank you in advance for a great panel.
Somebody want to field that? I'll start off just by saying that I think that's the idea behind this piece of legislation, that mHealth Developer Program is supposed to do exactly that, be a one-stop shop for folks that could come and ask questions specific to privacy and security and where they can go to find out more about specific regulations and how to get their product to market, their app. But with that, I'll defer to the panel.
Yeah, I mean, that's a great question, because there is no one place. And I think that goes across many different industries. There's a particular company can be subject to many different types of regulations, and is there one place where you can say, you can point to and say, this is the place to go where everything that should apply to me in terms of rules and regulations and guidances, this is where you should go for that. I think that I'm not aware of anything in the mHealth space where it is that one-stop shop. I think it's a great idea, particularly if we're trying to support an industry like this. But from an FDA perspective, you have to go to the FDA website, and with all due respect to the FDA, and I know they recently revamped their website, it's still not that easy to find things. And so to the extent there's anyone from the FDA out there in the technology section, it's still difficult. But a good keyword search on their website should pull up applicable documents. But the problem is that there's so many, and the diversity of documents related to what could be regulated is staggering. So,
I haven't heard that question before in this context, and it's a great question, and I agree there's no good answer. One of the things we've been talking about through the panel that occurs to me is, I was thinking of it from the perspective in which I see it, which is in the Garage Entrepreneur sort of triggered this. We're really talking about 3 government agencies regulating this space: the FTC, the FDA, and HHS. Now, there's not really an expectation right now that the Garage Entrepreneurs are going to know that, but certainly when companies acquire some of these more successful technologies, or even when companies are thinking about how to do diligence on their vendors, we put together diligence lists. And there really ought to be one that's available and accessible that covers the key issues. But I don't know of one, although maybe we'll put together one after this.
Right, exactly.
Exactly.
So I'm unaware of a single resource, but I could suggest an approach, if you don't mind. I do think that it's certainly wise to perhaps get people on board from legal with health IT expertise, people with cybersecurity expertise, your IT people, and even your intellectual property attorneys on board to examine that application from those various perspectives to make sure that your risk is minimized and that it's the correct solution. I don't think that there's, unfortunately, right now a single resource, and applications are all different depending upon what they do, but I certainly think that holistic approach might be a wise one to at least consider.
Yeah, and I would build upon Jamie's comments. FDA does have a site within their website called CDRH Learn, where you can go, but you're going to learn about the entirety of the body of law of regulations and medical device regulations and biologics and et cetera, et cetera. So it's not as easy to parse out what exactly you need. There's also a division for small manufacturers. That's a 1-800 line that you can call and ask questions. But it's only as good as it is, if you know what I mean. Okay. Next question.
I was going to just add another alternative is go to the horse's mouth and go to Google, put in HHS employee directory, and then enter Bakul Patel, and you'll get the horse's mouth.
Don't hit every regulator.
Right.
Just hit FDA.
Exactly.
Then you got to go to every other.
There you go.
Exactly.
So I have a couple questions, and I'll try to make them quick.
You get one.
Okay.
One question.
One question, and maybe I'll combine them two. So Jaron started out with the question of what frustrates you. And what I understood the frustrations to be are threefold. Uncertainty in the FDA, issues with privacy and security, and potential patent litigation issues. one of the things, so to give context to my question, my one question that I get from Jaren, I'm a scientist, biomedical engineer, lawyer focused on medical devices and mobile health, and an entrepreneur developing a medical device diagnostic mobile solution. One of the things that frustrates me is the lack of evidence. So the genesis, we talked about the genesis of the privacy and security being American Recovery and Reinvestment Act. In that, there was a lot of money for comparative effectiveness research, right? And that was something that was very controversial, and some people like it, some people hate it, right? But as a scientist, evidence is really important. And Jamie, you talked about the genesis of the medical device regulations being some issue that was the result of issues with medical devices on the market not being regulated, right? Snake oil, essentially. People making claims about things that it wasn't able to do. Concern for me is, as an entrepreneur developing a medical device diagnostic mobile solution, is that there are a lot of technologies on the market that say they can do things, mobile technologies that say they can do things that they can't. So my question is, what, from a policy standpoint, we're at a policy session, from a policy standpoint, what can the government do to push forward or drive evidence-based approaches to the use of mobile technology?
You know, that's a great question, Jason. And I think that, you know, when you think about agencies, and of course Marcy will be able to weigh in, having had the direct agency experience, each agency has a different mandate. And you think about FDA's mandate versus CMS's mandate versus FCC's. So FDA's mandate is safety and efficacy. You know, what evidence, you know, what is your product safe and efficacious? And of course, safety and efficacy is going to depend on what is your product. If it's a drug product, then, you know, you need two clinical trials, randomized and blinded, and you need to, you know, have a huge, robust portfolio of data. With respect to medical devices, it's going to depend on what class your device is in. Class 1, you're basically unregulated. You have the lowest level as possible. Class 2, you basically need to just say that I'm substantially equivalent to this other guy who was on, you know, who is substantially equivalent to this other guy, who is substantially equivalent to some product that was on the market before 1976. In Class 3, of course, it's, you know, back to that drug-like regime of randomized controlled clinical trials that are of a large scale. But, you know, I think that you raise a good point, which is what can we do to, you know, to really enhance the evidentiary. But I think it's really going to depend on what is the agency looking at. From an FDA standpoint, they're looking at safety and efficacy. And, you know, the level of evidence is going to be determined by what your product, and in your case, your solution is, what class your product is in. And if it's, you know, the levels of evidence can vary. And I think from a CMS standpoint, it's an entirely different mandate with.
It is. In terms of what the agency, well, first of all, evidence-based medicine, which means everything in the world to everybody, near as I can tell, is a thing that people like to say, and it's a thing that's hard to measure. In terms of what the agency can do, the biggest lever the agency has, HHS has, is payment. And to the extent they pay for things that the evidence shows works, however you define that, that's going to drive evidence-based medicine. So I think that there are a number of initiatives throughout the department, from funding studies to regulatory requirements. It's a big issue right now, and my sense of it is because it's controversial, because it's hard to measure, because there are a lot of different views, that means it's going to go slowly in the right direction. And in terms of, you know, that's, you know, so you've got the universe of approving devices. There are a whole bunch of things in the mHealth world that never touch the FDA and that never touch payment for health care through Medicare or Medicaid. So you also have, again, this trifecta. You have the FTC, which can bring enforcement claims against, or can bring claims and actions against folks that have devices, apps on the marketplace that say they do things that they can't. So I think that there are a couple of drivers.
I'll say a couple words here. I believe that the NIH is trying to get at some of the evidence. I know that they have a number of things that are coming out of the Office of Behavioral and Social Sciences Research, including an mHealth Training Institute that they hosted, I believe, right before this conference on Saturday and Sunday. That's one way of getting towards the evidence of whether or not these things work, but that's a very rigorous scientific way of approaching it, which is not really how the industry is approaching getting these devices to market, which I think is what more your question is. One place that I thought would be a natural for this would be the Patient-Centered Outcomes Research Institute, PCORI, but I haven't really heard much interest or anything from there. The Agency for Healthcare Research and Quality. The agencies are there. It's putting these types of questions before them to get them to do something, with regards to this. I'm really hoping that the NIH actually will step up its effort and try to go out to the industry. I think that was part of the idea behind forming a private-public partnership on evidence and specific in mHealth. But we'll see where that goes. Sir, question. Sure, ladies before gentlemen. Ma'am, you go.
Thank you for a great panel, great questions. My name is Indira Javaji. I'm a physician, so I'm giving you my perspective from that of an end user of mobile health. And we frequently send email messages, text messages. However, when I send a text message or an email from a computer, there are different agencies that are involved, which is HHS, which deals with the HIPAA privacy. And if that email goes to a physician, then that HIPAA privacy is definitely more enforced. Whereas if that email goes to a patient, then aside from the HIPAA privacy, I have other issues, regulatory issues, which now include the FCC, which drives the communication channel, right? They are the ones that do the communication for telephones and mobile, anything that is mobile. So my question to all of you is, as an end user, I'm texting patients, I'm emailing patients, I'm emailing physicians, and we're exchanging that information. How can you make our life easier for us to use this without falling into any of the regulatory burdens that are placed upon us? That's question 3.
How about we start off with Lee and go to Marcy? Lee, did you have an answer or? No, that's okay. Jamie, did you have? Jamie's biting at the bit. I'm going to
I was just going to say,
chew through his tongue.
if you're a physician who's trying to contact patients by email, thank you, because it is so hard to get doctors on the line. It's just so hard, and they don't like to email, and so I really appreciate that as a patient.
Well, we've excluded the insurance companies from here. The reason people don't like to email is who pays for the cost for those emails?
Yeah.
It is still my time. And I'm commuting and communicating with the patient. So who's reimbursing me for that time? So I'm just throwing it out for people to think about these challenges that we face that are not talked about in these places.
So I think that there are there are two thoughts I have about how to help or what can help. In terms of reimbursement for time, and I think again this is another area we're moving in the right direction, but it will be slow. Where you see payers beginning to pay for at least telephone consultations and maybe other kinds of mobile-enabled consultations. So we're going to see slow progress in that area, but that's something that needs to happen. And in terms of the privacy and security protections, just a very practical thing you can do is if you get permission, sort of a written permission, documented permission that your patient wants you to communicate with them via email, that can help guard against missteps. But it's a simple step to take that can provide some protection to you in both that they want to be contacted by email and that an affirmation that this is the number or the address that they want to be contacted, and then you update that from time to
That's
time.
great. I did not bring up the issue of practice of medicine. If I communicate with a patient, that does not really constitute, via email or text messages, that does not really constitute a practice of medicine, which is why the insurance company says, I'm not going to pay you because you're not actually practicing medicine. So you have all those issues in front, and as an end user, as a physician, how can even comprehend how to handle these things?
I think that part of the solution is actually on the design end. We should put more responsibility on the developer end so that they can design something that is HIPAA compliant so that there's less of a burden on the end user. And I think that the design aspect needs to be focused upon more.
Yeah, I mean, just one follow-up, which is to say, even if you get consent or permission documented from the patient, there's no doubt about it. You're right that there is still risk, not only on the privacy and security front, in doing that. So, and that's why we're starting to see the emergence of other types of solutions, secure systems through which patients can communicate with patients and other physicians. So
So I was just going to say, before we lose everybody, I just want to make one last plug. There's a federal policy update this evening at 5 p.m. at the National Harbor, 12 and 13. Bakul Patel from the FDA will be there. David Muntz, the Deputy National Coordinator for the Office of National Coordinator, and Julia Snap from the FCC. So I encourage all of those of you that are interested. We have one last question, and then we're done. Go ahead, sir.
Thank you. First of all, great panel. I'm Ravi Koparaj. I'm CTO and co-founder of a mobile patient monitoring company outside of Lowell, Massachusetts. I had one quick question. With all the regulatory stuff, guidance documents, et cetera, coming from the FDA, FCC, and everybody, what will be the burden of proof for solutions that use mobile technology, cloud, et cetera? Will NIST standards be the burden of proof, or will we be left with kind of, again, going to the cottage industry of consultants who will let us know, whether we comply or not, are we going to make people like Lee very rich?
This is, I guess part of the excitement of being in this field is that even when it comes to regulatory compliance, some of this is best guess. So there's not, it's the entrepreneurs, it's the people who are willing to take some risk and come out ahead that are going to go first. But either you got to use a consultant, you got to do best guess, or you really, or some kind of find other ways to access subject matter experts that can help mitigate the risk, because you're never going to eliminate it in this kind of an industry because things are changing too quickly.
And Ali's wrapping it up.
Just one comment. I think you've got to find what may work for you. And an example of that is in NIST Special Publication 861, at the very end of the document, there's a one-page checklist if there's a mobile device that's lost or stolen, kind of incident management. So, whatever you decide to do, you've got to document what's the framework you're going to be using and stick with it. Typically, NIST would be a good source to go to.
Great. With that, please join me in giving the panel a hand. Thank you. Thank you for coming.